Just think of a world where stealing does not result in a warning, a fine, or a prison sentence, but instead leads to the cutting off of your hand. To the modern mind, this punishment may appear extreme, even inhumane. In an era shaped by human rights discourse, rehabilitation programs, and prison reform, such a penalty feels shocking and difficult to accept. Yet for centuries, this law has existed within religious and legal traditions, particularly in Islam. To understand it fairly, one must move beyond emotional reactions and examine its historical context, purpose, conditions, and consequences. This discussion is not about promoting or condemning a particular legal system, but about understanding it. This video explores the punishment of theft from an Islamic background, discussing when and why it was introduced, its benefits and drawbacks, and the broader moral and social philosophy behind it. Theft has existed as long as human societies themselves. From the earliest tribal communities to advanced modern states, the act of taking what does not belong to you has been viewed as a serious violation. Theft is not merely the physical act of taking property, it represents a breakdown of trust, a threat to security, and an attack on social stability. Across civilizations, whether in ancient Rome, Hindu legal traditions, Judaism, Christianity, or Islam, stealing has always been considered a crime. What differs is not the moral judgment of theft, but the method of punishment. Some societies imposed fines, others relied on imprisonment, exile, public shaming, or corporal punishment. Each system reflected the values, resources, and challenges of its time. In early societies, where survival depended heavily on limited resources, theft could threaten the well-being of entire communities. Losing livestock, food, or tools was not a minor inconvenience, it could mean starvation or death. As a result, harsh punishments were often seen as necessary to protect the collective. In societies without modern policing, forensic science, surveillance cameras, or centralized governments, maintaining law and order was extremely difficult. There were no large prison systems, no long-term incarceration facilities, and no guarantee that criminals could be securely detained. Punishments, therefore, were designed to send strong and visible public messages. The aim was not only to punish the criminal but also to deter others from committing similar acts. Justice was meant to be swift, clear, and unmistakable. In this context, physical punishment served as a powerful warning in societies where abstract legal threats held little weight. Understanding this reality is essential before judging any historical legal system by modern standards. The punishment for theft in Islam originates from the Quran, specifically Surah Al-Ma'idah, verse 538, which states that the hands of a male or female thief should be cut as a consequence of their crime. This verse is often quoted in isolation, leading to misunderstanding and controversy. In verse 538, the word yad is translated literally as hand. However, the term yad can also mean strength of hands, power, property, and wealth. Different Arabic words have multiple meanings, and it is crucial to note that the right interpretation will always depend on the situation. Because the context here is stealing, some modern-day Quran research scholars believe the punishment should be recompensed for wealth rather than hand for wealth. If, on the other hand, verse 538 is accurately translated as cutting off the bodily hand, then verse 539 cannot be supported logically. According to them, it would be absurd to claim that Allah accepts a contrite criminal who is now missing a hand. How can forgiveness be justified after such a severe punishment? To them, if the thief returns the stolen items and repents and reforms, he will be forgiven. This law was introduced in 7th century Arabia, a region characterized by tribal conflict, weak governance, and widespread insecurity of property. Theft, raids, and looting were common. There was no formal police force or prison infrastructure. Justice was often enforced through tribal retaliation, which led to cycles of violence and revenge. Islam emerged in this environment to establish order, justice, and moral accountability. The introduction of a clear legal framework covering contracts, property rights, family law, and criminal justice was revolutionary for its time. Contrary to popular belief, Islamic law does not apply the punishment for theft blindly or automatically. Classical Islamic jurisprudence places strict and detailed conditions on its implementation. For the punishment to be applied, the theft must not be driven by hunger, poverty, or necessity. The stolen property must reach a minimum value known as nisab. The property must have been taken from a secure place. The act must be deliberate, intentional, and secret. There must be clear evidence, such as a voluntary confession or reliable witnesses. Any doubt invalidates the punishment. If even one of these conditions is not met, the punishment cannot be carried out. This legal principle is rooted in a famous Islamic maxim: avoid applying punishments when there is doubt. As a result, historical records indicate that this punishment was extremely rare. Its primary function was not frequent enforcement, but deterrence. Another crucial aspect often overlooked is that Islamic law ties criminal accountability to social responsibility. Islamic governance places heavy emphasis on ensuring basic needs, food, shelter, and security for all citizens. If a society fails to provide these necessities, it loses the moral authority to impose severe punishments. A famous example comes from the era of Caliph Umar ibn al-Khattab, who suspended the punishment for theft during a famine, recognizing that hunger and desperation removed moral culpability. This demonstrates that the law was never meant to operate in isolation from social justice. Consider a city governed by Islamic law, where social welfare systems ensured that basic needs were met. Markets were secure, trade flourished, and people trusted one another. Theft was rare, not because people were morally perfect, but because the system discouraged it effectively. One day, a man who was neither poor nor desperate stole valuable goods purely out of greed. An investigation confirmed that he had access to lawful income and that the theft met all legal conditions. After due process, the punishment was carried out. Fear spread through the city, not fear of oppression, but fear of accountability. People understood that justice applied equally, regardless of status or power. Over time, theft nearly disappeared. Shopkeepers no longer locked their doors, and travelers felt safe carrying their wealth. The punishment of one individual served as a lesson for an entire society. This story illustrates how the law functioned not as an instrument of cruelty, but as a mechanism for social stability. One major benefit of this punishment is its powerful deterrent effect. The severity and visibility of the consequences discourage people from even considering theft. In societies where the law was implemented justly, crime rates, particularly theft, were historically low. Another advantage is the protection of property rights. When people feel secure that their property is safe, economic activity increases. Trade, investment, and social cooperation flourish. This benefits both the rich and the poor. Islam also emphasizes justice over revenge. Transferring the right to punish from individuals to the legal system, it prevents cycles of personal retaliation. Victims are protected, and criminals are held accountable through due process rather than mob justice. Furthermore, the strict conditions attached to the law ensure that the poor and desperate are not punished, reinforcing the principle of fairness and moral responsibility. Despite these advantages, the punishment faces serious criticism in the modern world. Physical punishment is irreversible. Once a hand is cut, it cannot be restored. Critics argue that such penalties violate human dignity and bodily integrity. Modern human rights frameworks emphasize proportionality, rehabilitation, and reintegration into society. From this perspective, corporal punishment appears harsh and incompatible with contemporary values. There is also the risk of misapplication. In societies with weak judicial systems, corruption, or political misuse of religion, such punishments could be applied unjustly. This concern is not theoretical. History shows that any law, if abused, can become a tool of oppression. For this reason, many Islamic scholars argue that this punishment can only be applied in an ideal Islamic state, one that ensures justice, welfare, transparency, and due process. Without these foundations, enforcing such laws would contradict Islamic principles themselves. The debate today remains deeply divided. Some argue that modern prison systems have failed to reduce crime and often produce repeat offenders. Others believe that harsh punishments create fear rather than moral reform. This raises fundamental questions. Is the purpose of punishment to deter, to rehabilitate, or to express moral condemnation? Can a balance be found between justice and compassion? Should laws be judged solely by modern standards, or within their historical and cultural contexts? The Islamic punishment for theft was not designed as an act of cruelty, but as a mechanism to prevent cruelty, protect society, and establish justice. It emerged in a specific historical context and was governed by strict conditions that prioritized fairness, social welfare, and moral accountability. Understanding this law requires more than emotional reaction or selective quotation. It demands context, balance, and intellectual honesty. Whether one agrees or disagrees with it, dismissing it without understanding its philosophy does little to advance meaningful dialogue. The question ultimately remains open: does harsh punishment effectively eliminate crime, or do modern rehabilitative approaches work better? What do you think? Is strict punishment necessary to maintain social order, or should societies rely on alternative methods to deal with crime? Share your thoughts in the comments below.